Hello, class, and welcome to PLS 103, Introduction to Law. To begin with, I thought I'd provide you an overview of the modern legal system. We'll start with a definition of what the law is. Law, also known as a legal standard or a legal principle, comes in many different forms and from different sources, seen here. It can apply to people in general, a particular group of citizens, or a specific person or entity, such as a corporation. The first source of law that you should be aware of is statutory law. Statutory law is enacted by a state legislature or by Congress. If a state legislature enacts a law, all persons and entities legally present in the state must obey it. If Congress enacts a federal law, all persons legally present in the nation are required to follow it. Once approved by the legislature, a statute will generally continue indefinitely as law until either the legislature repeals or deactivates it, or the high court of the state or federal government rules it unconstitutional. It's important to note that federal laws must be consistent with the U.S. Constitution, and state laws must both be consistent with the state constitution and the U.S. Constitution. And no state constitution can conflict with the U.S. Constitution. The provision of the Constitution which states this principle is known as the Supremacy Clause. While statutory law is of preeminent importance, the language of statutes is necessarily broad to include as many potential situations as possible. This can be problematic in some cases, where the court will determine that the law is written so vaguely that citizens cannot determine what is and is not acceptable conduct. In these cases, the law will not be upheld as valid. But even in cases where a statute is not constitutionally vague, judicial law will be necessary to interpret the law of these statutes. And this is the second source of law. In judicial law, the judiciary interprets law from other sources and has power on occasion to create legal standards known as case law. Judges may consider a legal standard and determine whether it was meant to apply to the circumstances of a particular case. Persons in similar situations may then look to the judge's decision to guide them on their own conduct. When no law exists, judges are responsible for making law and extending decisions of judges in similar cases. This continuation of existing legal standards is commonly referred to as stare decisis. This literally stands for let the decision stand. This principle requires courts to follow the same legal principles in similar cases, and that this gives consistency and stability to the law. People are better able to know what they are to do when they can look to the past for guidance and what to expect from courts in the future. And when a court applies this principle of stare decisis, it is known as following precedent. That is, a previously established legal standard. It's important to note that this class will focus in many ways on an interpretation of these cases, as they provide a good examination of these principles in action. And to this word, I want to take some notes about how you should be reading these cases, starting with one of the first cases in your reading. This is the In the Matter of the Estate of Mark R. Beauregard. When you are reading these cases, it's important to break these down into four distinct elements. First, you must be aware of the facts of the case. The facts will inform the court's decision, as cases are often supposed to be fact-specific. Next, you need to examine what legal issue the court will be considering. Then you will need to know the legal principle or the law that the court will be applying in order to reach a result. And then you will have the rule, which is after applying the law to the facts, you get an answer to the issue and a continuation of this case law known as precedent. So in this case, you'll notice that the decedent died unmarried and childless, leaving his parents as his sole heirs. The plaintiff, who lived at the same address as the decedent, produced a copy of the decedent's will, in which significant assets were bequeathed to the plaintiff. The plaintiff filed a petition for probate of the copy of the will because the original will could not be located. The decedent's parents and siblings filed objections to the petition. The trial court applied the evidentiary presumption that when a will was known to exist cannot be found, it is presumed that the decedent destroyed the will when they attempt to revoke it, and the trial court found that the decedent had indeed executed a will, but the plaintiff But the plaintiff failed to rebut the presumption that the decedent destroyed the will with an intent to revoke it. The trial court dismissed the plaintiff's petition, and then the plaintiff appealed. At this stage, it went to the appellate court. The appellate court was deciding the issue of whether the trial court erred in finding the plaintiff had failed to rebut the presumption that the will that was known to exist and could not be found was destroyed by the decedent with the intent to revoke it. And of course, to reiterate, the law in this area is where a will is once known to exist cannot be found after the death of a testator, that is a person who dies with a will, there is a presumption that it was destroyed by the maker with an intent to revoke it. To rebut this presumption, the plaintiff must demonstrate by a preponderance of the evidence that the testator did not destroy the will with the intent of revoking it. In this case, the appellate court ruled that because the trial court found that the decedent was young, healthy, and fully competent at the time of his death, it was unlikely that the testator lost the will. The trial court also noted that there was only a brief time between the date the will was executed and the decedent's death, which left little time to lose it. As such, the trial court made its decision to deny the petition for probate. The appellate court decided to uphold this ruling because it was not shown by a preponderance of the evidence that the presumption that the will that could not be located was destroyed by the decedent with the intent to revoke it. Here it's important to note that typically appellate courts give wide deference to a trial court's findings of fact, which can only be overturned if they are somehow shown to be clearly erroneous. And from this, it is important to note that there's four elements of these cases are there to help you break these down into more manageable sites. You need the facts to know what's going on in the case. You need to know the issue that the appellate court is deciding. You need to know the law that the appellate court will be using to determine the result of the case, and you need to know how the appellate court is going to apply the law to the facts to resolve the issue to get a ruling. And if you can find all of these things, you will be able to quickly get through these cases in an efficient manner. This leads us to our third and final source of law that we will discuss in this unit, administrative law. Earlier we discussed how judicial law is largely concerned with filling in some of the gaps, and statutes were often very broad in order to cover a wide variety of situations. Well, with the growing complexity of the economy in the modern age, a new area of law, administrative law, has arisen to fill in some of the gaps of judiciary law, as you need a panel of experts often to determine and apply correct decisions in these technical fields. Administrative law primarily consists of two elements: administrative regulations, sometimes called rules, and administrative decisions. And administrative law is an extension of statutory law established by Congress. Failure to obey this law can result in penalties or even criminal prosecution. Administrative agencies issue regulations or rules that more specifically define the broadly written statutes. Administrative decisions issued for highly specific cases have the same effect of law as judicial or legislative law. These cases often involve persons or entities that challenge the authority of the agency to issue and enforce a particular regulation. And with that discussion of the sources of law, it is time to go into a discussion of the hierarchy of United States law. First in the hierarchy is the United States Constitution. Although technically the Constitution and its amendments are statutory law, they are considered superior to all other law because they establish the governmental structure and the process for creating all other law. Next in the hierarchy of law are the legislative or statutory acts of Congress. Statutes have greater weight than judicial or administrative law because statutes are enacted by Congress and state legislatures, which are composed of people elected by people. Thus, statutes are most likely to represent the laws intended for and desired by the majority. The judiciary has the authority to interpret legislation and to fill in gray areas where the law is unclear or non-existent. The judiciary is also obligated to ensure that the law is consistent with the Constitution. When the judiciary determines that the law does not meet the requirements of the Constitution, it has the authority to declare the law invalid and thereby supersede the ordinarily superior statutory law. Constitutionality is the only basis for judicial rather than statutory law controlling an issue. Last in the hierarchy is administrative law. Administrative agencies assist Congress by issuing regulations and decisions that clarify and aid in the enforcement of statutes. However, Congress has the right to eliminate an agency or regulations that are inconsistent with legislative objectives. The judiciary also has the authority to overrule actions of an agency when such actions are unconstitutional. And that concludes our discussion of the Chapter 1 material. We will continue this lecture with Chapter 2. Moving on, we will now examine the role of the judiciary in more detail. The judiciary is responsible for reviewing the acts of Congress and the executive branch. Doing so, it is expected to have the knowledge and objectivity to examine individual situations and determine appropriate legal standards and how they should apply. This is what is meant by the letter and spirit of the law. It provides access to the governmental system for the entire populace, and, when working properly, it is designed to provide fairness and enforcement of rights of all purposes. Interpretation of statutory or administrative law is one of the most important functions of the judiciary. This occurs any time a statute or administrative regulation or decision is at issue. The statute and the facts of the case are reviewed, and applicable legal standards are employed to determine the result. It's important to note that no two cases are exactly alike, but a judge may apply the same ruling used in previous cases that have striking similarities on the facts or the legal issues involved, or both. This is what is involved with stare decisis that we discussed earlier. When no prior judicial precedent or applicable statutory administrative law exists, however, a judge must create the legal standard. This is known as common law, a term that is carried over from medieval times when judges created law for the common man. Technically, common law is defined as newly established legal principle, whereas case law is the application of stare decisis, perpetuate and continuing application of a prior legal principle. In actual practice, the terms common law and case law have come to be used interchangeably. The basic concept is that the terms represent judicially created law. Now that we have a firmer grasp of what courts do, it's time to delve more deeply into how the court system is structured. Federal and state court systems consist of two basic types of courts, trial and appellate. The trial court is the court in which the case is presented to the judge or jury. In the trial court, each party follows certain required procedures to prepare the evidence for a fair and complete presentation. The judge and, in many cases, a jury hear the evidence to support the claims of both sides of a dispute. When this is completed, a verdict is then given that declares whether the defendant is at fault for violation of a legal standard. The trial court is often known as the court of original jurisdiction. This is where the case is determined for the first time, or originates. If a party believes the trial court verdict is a result of a failure to properly follow legal requirements for the proceedings, then the party may choose to appeal the verdict. When a case is brought on appeal, the judges of an appellate court will review part or all of the trial court's proceedings. An appellate court has authority superior to that of the trial court and has the power to change the trial court's verdict. And appellate courts often consist of several judges who review the case as a panel. By utilizing multiple reviewers, there is less chance that mistakes will be made in review of an application of law to a particular case. And it is the duty of the trial court to determine the applicable law, hear the evidence, and render a verdict, whereas it is the duty of the appellate court to only review what took place in the trial court and determine whether the law was correctly applied to the evidence presented. Appellate courts generally do not hear new evidence such as testimony of witnesses, nor do appellate courts issue new verdicts. Rather, they affirm, that is approve, or reverse, that is reject, the trial or lower court's verdict. As you can see with this slide, the federal court system started with a single court, which is now known as the U.S. Supreme Court. Over time, Congress added several courts to the federal judicial branch. Currently, the federal court system comprises 3 levels, each of which functions totally independent of the state court systems, just as each state judicial branch functions independent of the other states. This chart memorializes the relationship between these levels of courts. As you can see, of the 3 levels of trial courts, the trial courts, where the vast majority of federal cases originate, are known as the U.S. District Courts. Generally, the U.S. District Courts are used as trial courts. However, in limited circumstances, a federal case can initially be heard by an administrative hearing officer with the executive branch and appealed to U.S. District Court. In such instance, the U.S. District Court takes on an appellate authority rather than its usual original jurisdiction. Also, there are highly specific types of cases that may initially filed for trial at the appellate level that bypass the U.S. District Court altogether. Typically, the appellate level is reserved for parties who wish to challenge the decisions of a U.S. District Court. Such an appeal is made to the next level, which is the U.S. Court of Appeals. These are divided up into several circuits, which are based geographically. Currently, there are more than 90 U.S. District Courts. Congress has increased the number of these courts when warranted by the number of cases filed and tried in the federal system. When the burden becomes too heavy for one court, Congress creates additional courts to handle part of the load. And these courts are separated by geographical boundaries. Legal disputes over federal law that occur or have connections to the court within the court's physical boundaries are subject to the authority of the U.S. District Court. At the top of this pyramid is the United States Supreme Court, the final authority on all matters of federal jurisdiction in the U.S. legal system. The court cannot overrule Congress or the President unless the legislative or executive branch has in some way violated or exceeded the authority granted to the branch by the Constitution, and that action has been challenged in court. The Supreme Court's primary function is one of review. It reviews cases from the federal courts, and in some cases, from those highest state courts that have constitutional issues, or that include the government as a party. The key element in the authority of the Supreme Court is that there must be a federal issue at stake, either in the form of the parties involved or the constitutionality of state or federal law. It's important to note that the court does have some original jurisdiction, but this is limited by the types of situations specifically mentioned in Article 3 of the Constitution. And the U.S. Supreme Court has 2 common methods of obtaining review. The first is by right. Certain types of cases are automatically entitled to review by the Supreme Court if the party so desires. The court will review the case as long as the procedural rules for filing the appeal are met. The second, or more common method, is known as certiorari, which describes the authority of the court to accept a number of cases for review where there are no right, but where it would serve the interests of justice to have the court make a final and ultimate determination of a legal standard. It is important to note that although many parties seek Supreme Court review, the court grants review in limited cases where there are important legal issues at stake or there is a split between circuits. It is also important to be aware of the state court system and how these are organized. There are 2 basic judicial structures in the state courts, the 3-tiered and 2-tiered system. The 3-tiered system is comparable to that of the federal court. The 3 tiers are a court of last resort, which is the highest court of the state. There is also an intermediate appellate court and a trial court level. The alternative is a 2-tiered system consisting of only one appellate or Supreme Court and the various trial courts. However, because of an increase in litigation, more states are relying upon the 3-tiered system. This chart provides an overview of a 3-tiered court system inside the states. Very useful. For the 2-tiered system, you can just get rid of the Court of Appeals, and all you would have is a trial court or court of original jurisdiction and a single appellate court. To conclude this week's material, I want to discuss the process of a legal analysis in more detail. As mentioned earlier, judicial opinions should be briefed in the following manner by breaking it down into the facts, the issue, the law, and the rule. The first one of these elements is the facts. Although there may be a number of these, it is important to limit your analysis to the key facts. These can generally be divided into two types of key facts: the occurrence facts, the details of the circumstances. The ones here that you should be focusing on are the ones that will inform the court's decision. The other type of facts that you need to be aware of is the legal procedural facts, and this is an analysis of what happened in the courts prior to it being presented to the appellate court. The next element is the legal issue. Here, it is not necessarily just whether the defendant is liable or guilty. What is really at issue here is whether something occurred at the trial court to prevent the proper finding of guilt or innocence or liability or not liability. Next is the law. This is the authority on which the court's decision will be based. And it is important to note that this, again, may be a statute, it may be the Constitution, or it may be prior court decisions. Finally, we have the rule, which is the court's analysis of why the law and these facts lead to a certain decision. And with that, we have finished the Week 1 lecture. I will see you guys next week.